That actually gave rise very soon to what came known as sham issue advocacy. And the classic sham issue advocacy advertisement on television and radio was one that said, Bill Yellowstone beats his wife. He does not believe in family values. Bill Yellowstone was running for Congress. I guess it was in Colorado. Bill Yellowstone beats his wife. He doesn't believe in family values. Call Bill Yellowstone and tell him to stop beating his wife. That was okay to use corporate money to say, because they didn't say vote against Bill Yellowstone. They just said tell him to stop beating his wife. So that gave rise to this whole field that was known as sham issue advocacy. It wasn't an independent expenditure. It was an issue advocacy. That created, well, then there are two other cases that became important in the 1980s. One was the case of Austin versus Michigan Chamber of Commerce. The state of Michigan prohibited corporations, but not unions, from making independent expenditures in support of political candidates, and the Chamber of Commerce challenged that under the First Amendment of the federal Constitution. An opinion by Thurgood Marshall upheld the Michigan statute. That opinion said because of the corrosive effect of corporate expenditures in the political process, it was appropriate for a legislative body to prohibit even independent expenditures by corporations. And if Michigan didn't want to extend that ban to trade unions, that was okay. The Michigan legislature did not have to. That was a political decision. A couple years later, the issue came up as to whether nonprofit organizations, such as the anti-abortion group, case came up in a case called Massachusetts Citizens for Life, and they were a corporation, and the question was, were they similarly forbidden as a corporation from making independent expenditures out of their corporate treasury? And again, in a decision dominated by Thurgood Marshall and William Brennan, they said that was okay. Nonprofit corporations such as Citizens for Life, or the NRA, or Emily's List, or other nonprofit organizations, NARAL, they could make such expenditures because it was not business, as long as they didn't accept into their treasury contributions from business corporations. As long as it was money contributed by their own members and individual supporters, that was okay. The First Amendment protected their right of association as ideological organizations to make those contributions. So that was an important distinction. It was basically set by Justices Marshall and Brennan because they shifted sides in the two cases, that business corporations could not make such expenditures, but nonprofit ideological corporations could. And that was the basic law, which was somewhat extended in 2002 in the McCain-Feingold Act. And what McCain-Feingold did was they did several things, but one of the most important things they did was to try to get around the Bill Yellowstone problem. That to deal with this sham issue advocacy. And they tried to say, no, even though it doesn't use magic words, vote for or against, if it's clear that the message is to support or oppose a candidate for office, and this was during the last 60 days before an election or 30 days before a primary, and was only applicable to television and radio advertising, not print advertising. McCain-Feingold said sham issue advocacy was no longer acceptable. And in the first go-round, the U.S. Supreme Court upheld that. This was in McConnell versus FEC, which is around 2005 2005 or 2006. And in a 5-4 vote, the Supreme Court upheld this prohibition on sham issue advocacy, with Sandra Day O'Connor casting the decisive vote. She joined the 4 liberal moderates on the court against the 4 other conservatives and upheld McCain-Feingold. Then, 2 years later, Sam Alito replaced Sandra Day O'Connor on the court. And what we now had was a Supreme Court which was really solidly supporting deregulation of political campaign financing. And that's what we have now. We basically have a Supreme Court which opposes regulation of political campaign financing. And yeah.
You have a divided Supreme Court.
What's that?
You have a divided Supreme Court.
So it's 5-4, yes.
4-5.
It's 5-4. Usually Justice Kennedy is the swing vote these days. Sandra Day O'Connor used to be the swing voter. But in almost every major issue these days, it's Justice Kennedy who's a swing voter. And unfortunately, on campaign finance, Justice Kennedy is a deregulator. So just about 3 years after McConnell versus FEC, the Supreme Court essentially overruled itself in a case called Wisconsin Citizens for Life. Or Wisconsin Right to Life, WRTL. And there, essentially, they went back to sham issue advertising and said, no, unless the ads really say vote for or against, and it's unmistakable what the message is, you can't prohibit it, even though you have corporate money involved in spending it. So McCain-Feingold took its first beating then, and it's become clear in the past couple of years, since then, 2008, 2009, 2010, that this present majority is hell-bent on deregulating the whole campaign finance issue. And it would not, there is still a prohibition going back to the FECA in the 70s that business corporations cannot make direct contributions to political candidates. But even that is probably on very shaky grounds these days, because this 5-4 majority is pretty clear in favor of deregulation. They take the notion that corporations have free speech rights like ordinary citizens. And that's when we come to Citizens United. Citizens United was actually a very uninteresting case. It wasn't of great consequence on the facts. It could have very easily been decided a dozen different ways without basically changing the law. Citizens United was a right-wing, allegedly nonprofit group which produced a campaign film about Hillary Clinton, movie Hillary. And it obviously was trashing. It was during the Democratic primary, and the film was trashing Hillary. And the Federal Election Commission ruled that they could not use their corporate funds to promote the film on television. Now, they weren't going to show the film on direct access television. It was only on films on demand. You had to, you had to ask for it. You wasn't going to see it on regular television. You had to order the movie. And the case could have been decided, got written up 6 different ways, that it really didn't violate the law, that Citizens United was really a non